Welcome, everyone, to our webinar about US immigration and the changes or the planned changes under Donald Trump. My name is Victoria Liedl. I'm with the Advantage Austria office in New York. I'm kind of your host today. I'm covering topics such as startups and innovation at our office, but also requests coming from Austrian companies regarding any immigration question are answered by me together with our trusted lawyers. One we have the honor today to have as a speaker. In a few days, as we all know, Donald Trump's inauguration will happen, and many things are very uncertain. No one really knows what's going to happen. However, some topics, especially when it comes to immigration, were already revealed and are kind of certain, or we're planning to plan for the uncertain. A few housekeeping rules for today. We're going to have a Q&A session at the end, but please feel free, if you have questions while the presentations, to just drop them in the Q&A field. We will record this webinar, and we will share the recording as well as the slides a few days after the webinar. We do have two speakers today, and I'm very happy to welcome our Deputy Trade Commissioner, Lukas Zitz, today. He's going to give a quick overview of, as I said, like, what can we expect with Trump? And then we also have our trusted lawyer, Christian Zeller here with us. He's also the Austrian Honorary Consul in Tampa, and he will give you an overview of, as I said, what's planned under Trump, what do we know already, what do we don't know, and what can we expect. All right, so without further ado, I'll hand over to Lukas.
Okay, perfect. Are we going to see the introductory slide? Good afternoon to everyone in Austria. Good morning to everyone in the US. My name is Lukas Zitz. I'm the Deputy Trade Commissioner for Austria here in New York. And together with our team and offices across the US, we help Austrian companies investing and exporting to the United States. Just one information why we're doing this in English. We're not trying to give you an English class or have forgotten to speak German. We can have all questions from your side in German. However, especially with the terminology around visas, we thought it would be better to do this in English, as most likely when there's further questions getting into details about your personal visa requests, and when you have to fill out forms, all this terminology will show up in English. And this is why we're conducting this webinar today in English as well. I will briefly touch upon what we perceive as the status quo for Austrian companies in the United States. And I will also give a point of view on the upcoming inauguration of President Trump. First of all, the United States is Austria's most important overseas export market. It's our second most important market for exports overall after Germany. And with the continued economic distress in Europe, we are expecting the United States to just become even more important of a trade partner. Now, that being said, you will all have heard in the news what the proposed policies of the new government in the United States are. The most famous slogan is "Make America Great Again," which does have a certain number of implications for Austrian companies conducting business in the US that I will briefly touch upon. Can we go to the next slide, please? this is a very brief overview of what we are most likely going to see in the presidency of Donald Trump. There will be, we are expecting to see a new political world order to evolve, and particularly, I have quoted a few statements from a recent article from the Economist here. There will be a divergence into a multipolar or G0 world. What does that mean? It essentially means that the world order structured by multilateralism and cooperation, particularly among the Western world, is no longer a given, and that there is potential for disruption with countries that have been considered a long-standing allies. Now, that's not a certainty, but that's a trend that could happen. An example that we have recently all heard about was President-elect's plans regarding Panama and Greenland. Additionally, we expect to see a fragmentation of the world economy. So there will be certain blocks that are going to have stronger cooperation in certain regions, or even there will be cooperation among countries that share certain interests that are not necessarily restrained to geographic location, but also their interests. And what is also going to be of interest is that topics of national security, social, political, and environmental concerns might become more relevant. That means that I think the media these days conveys the message that business and the economy is the most important topic for the US. I personally think that there could be other topics that might be prioritized. An example is migration. Another example is the policies that were issued and shaped throughout the last administration in regards to climate protection. Some of these things we will potentially see to be reversed, and they will have an economic impact. However, they are not necessarily going to have a positive impact on the U.S. economy. Particularly migration, there is a hot topic because there is experts arguing that the workforce coming into the country through legal and illegal channels is contributing substantially to the United States labor force, and a change in that policy can cause major disruptions in the economy. And then on the second slide, we tried to give a brief overview of things that we expect to change or see potential for change. The America First approach that is proposed by Donald Trump will definitely take place. We also expect a stronger economic confrontation with China that is already imminent in the announced 60% tariffs on imports from China. We are expecting tax cuts, an increase of the budget deficit, because there have been certain measures announced that will cost, that will be very budget intense. And we're expecting the US to continue to grow from an economic perspective and trying to remain a leading power. There is the attempt to organize a reindustrialization of the US. So that is something that is proposed. However, with the measures in regards to tariffs, migration, and other policies we're not sure if that is actually going to take place. So it's something that the government wants, but it might be something that will take a long time to realize, or it might never realize at all. The turn away from multilateralism is something that is a subnote from the speeches that you can hear from representatives of the government elected. And I think one thing that I suggest Austrian companies regularly is to expect the unexpected, as you already had to do throughout Trump's first administration. On the right column, we have some parts that are uncertain. There will be definitely a new tariff regime. However, we do not know what this is going to look like. I think it does not make sense to elaborate on it too much for now. It will make more sense in a month or maybe even two to think about the change of tariffs, or whenever there's like a very definite announcement about the change. There will be an impact on the national debt, as mentioned, if the policies in the way they are announced are going to come into place. And massive deregulation has been announced. However, that is also something to be seen. And with that, I'm finishing my very brief introduction. Thank you, everyone. We are handing over to Christian Zeller, our migration lawyer.
Thank you, Lucas, and thank you, Victoria, for the introduction. This is our intro slide, and my email number is on there. And I think we agreed that if you have any questions after the presentation or in the future, that you first contact Advantage Austria in New York, and they will forward any inquiries directly to us. And with that, Victoria will go to my next slide. And of course, as you might all imagine, as a lawyer, my first slide is that of a disclaimer. So what you're going to hear today is based on historical events. I've been in this business for the better part of 30 years, and of course, we've lived through the initial Trump administration. So, you know, we have certain expectations, we speculate, we hear a lot on the street. But this webinar today is for informational purposes only. And it's also my understanding that Advantage Austria will provide you with a copy of this PowerPoint after the presentation. And just a word to the wise on that. While there is a lot, I think, valuable information in it, please contact us prior to acting on anything that you see in this PowerPoint, because those of you who have lived through the first Trump administration already know that immigration is a very fluid environment, and what may be true today or what I'm telling you today may no longer be true next week. Most importantly, we'll talk about Mr. Trump today, we'll talk some about Mr. Biden today, but I want to be very, very clear. None of what I say has to do anything with any political opinion. I don't have a political opinion. I only view these subject matters through the lens of immigration law, and I think this is where you benefit the most. And with that, let's get going, Victoria, and let's go to that next slide. So there's always good news also. As you know from previous administrations, an outgoing administration tries to get as much in the door before they leave. And the Biden administration has just done that. And there are some good news for some of our Austrian companies. First, if any of you employ persons in the H-2B category, those are temporary workers without degrees, and usually we have 66,000 of those per year, that has been increased to 130,000 per year. So that's a good thing. So take advantage of that while it lasts, because it's not going to last. There's also a new TPS, Temporary Protected Status designation for Lebanon, and the TPS designations for Sudan, El Salvador, Ukraine, and Venezuela have been extended. They have been extended for another 18 months, and they will last into 2026. And since we think that TPS is going to go away, I think that is important for many of our Austrian companies. I know for a fact some of you do employ individuals from Venezuela and from Ukraine. In the J1 world, if any J1 listeners are out there from any other countries listed here, you already know that many times when you have a J1, you are subject to what's called the 2-year foreign residence requirement. That has gone away for the countries listed if you're on the skills list. We're not going to spend any time on that, but I think it's important enough to mention it. More important for our listeners today is that if you have employees who are on work permits like H4s, H1s, L, E, and so on, and if those employees have to extend their employment authorization, if you file that employment authorization extension timely, you will get an automatic extension of 540 days. That's, of course, a great benefit. There is not going to be any work interruption, and the USCIS has enough time to adjudicate that employment authorization. Another good thing is that the H-1B modernization rule is going to go into effect tomorrow. We'll talk a little later about that. I think that's going to apply to many of you. And then in other good news, Romania is now a designated ESTA member. I know many of our Austrian companies have technicians from Romania that come to the United States. And while you typically do that under B1, you might be able to do that under ESTA now. And that will go into effect on or about the 31st of March. And with that, we'll go to the next slide, please. We'll talk first about some general expectations that we'll have from the incoming Trump administration. And of course, we have the benefit of the 4 years that Mr. Trump has already been in office. I can speculate on a lot of things, but this is one thing I can guarantee you that it will happen. There will be increased workplace compliance enforcement. And if you take anything away from this presentation today, then it is workplace compliance and enforcement. Now is the time to get your I-9 household in order. If you don't, I promise you, you will have a business interruption, maybe not next week and maybe not in a year, but it will come because there will be audits, there will be site visits, there will be fines, there will be prosecutions on the civil and on the criminal side. Those of you who have lived and done business in the United States for a number of years, you may remember the second Bush administration. In the 2000s, we had raids on factories, we had raids on businesses, we had HSI and FDNS officers walk into buildings and basically demand that the businesses show that their workforce was legal and that their I-9 household was in order. And we'll go to the next slide on that. There will be restrictions on work authorizations for students and for others. Now, this is something that's out in the street, and we don't know if it's going to happen. It likely will happen. And here's how we know that. In our immigration law, some things have to go through Congress. Anything that has to go through Congress is likely not going to happen. Anything that the administration can do without Congress by way of an executive order or just by way of coming up with a new regulation will likely happen. And when it comes to work authorizations for students and others, we're talking about students in OPT, we're talking about students in STEM OPT, we're talking about H4, the spouses of H-1B visa holders, we're talking about United for Ukraine, TPS, temporary protected status, and DACA, deferred action for childhood arrivals. None of those are enumerated in the Immigration and Nationality Act. They're just made up by way of regulation and by way of executive order. Some of you may remember DACA. It was enacted by way of an executive order by President Obama in 2012, and it's been on a lifeline since. All the Trump administration has to do is let it run out or terminate it. And going back to workplace enforcement, when you do your I-9s in your businesses, you might not necessarily know what kind of work authorization your staff has. From your Austrian employees, of course, you know it, but maybe your US staff, you don't know. They might be in TPS, they might be on OPT, they might be on STEM OPT, they might be on the United for Ukraine. You have to know this because these programs might likely go away. And we'll go to the next slide. there's definitely going to be elevated scrutiny of visa processing and embassies of consulates. And I know many of you have suffered through that already, but you need to brace for that as a business. If there's a possibility to renew a visa right now, renew it right now. Do not wait. If you can avoid international business travel, if your employee is, let's say, from a Muslim country or from a country that we had travel bans against in the past, or if your employees are from China or from India, be very careful when they travel internationally. Their return might not be as smooth as you think it might be. If you are sending some of your staff overseas to have their visas renewed, there might be a business interruption because the smooth renewal that you are used to from the past might no longer be there. So that's just something to keep in mind when you have your staff travel. If you don't have to travel, don't do it. And we'll go to the next slide, please. That's going to be enhanced limitations on visa-sponsored petitions. All of you, I know, you have heard about the H-1B. There's something in some paper every other day, and it's some horror news every other day. We'll talk a little close about the H-1B because I know that's an important visa. But do not underestimate the attack on the L1, which many of our Austrian companies use. Some of you who do not have an L1 blanket, who actually renew the individual L1 intra-company transfer visas, especially the L1Bs under specialized knowledge, they are under attack, and this will continue. The same applies if you employ Canadians in the TN category. We already experience now additional scrutiny at the Mexican and the Canadian border for TN applicants, and of course E3s from Australia, and that might not be as relevant to our Austrian companies as it is to many others. And we'll go to the next slide, please. Here's something that you all remember, buy American, hire American. And I promise you, it is going to be back. And here's how you are going to be impacted by that. Whatever application that you might be filing for a staff member, whether it's an L1, whether it's an H1B, whether it's an E2 employee, whether it's an E1 employee, you will have to prove by some arbitrary terms to the US Post overseas where that visa is issued as to why you are not hiring an American for that position. I do recall during the first Trump administration, we had a legal argument on every single visa application about buy American and hire American, and why our foreign national, and specifically why our Austrian employees come within the purview of having a visa issued, and that buy American, hire American does not apply to them. There will be intense investigations coming by the Department of Labor when you file perm applications, when you file H-1B visa applications, and of course the famous RFEs from the U.S. Citizenship and Immigration Services asking you as to why an American cannot do that job. And we'll go to the next slide, please. So now let's talk about some specific situations. If you have employees that are in DACA, or if you are a DACA recipient and you're listening today, you can count on one of two things to happen with DACA. It's either going to be terminated or it's just going to expire on its own. My personal guess would be they're just going to let it expire because guess what? You don't have to do anything. Just let it go. This attack on DACA, of course, has been ongoing since 2012, and the last attack on it was in December of 2024. All Obamacare possibilities were stopped, the health insurance for all DACA recipients. So we think that it will be eliminated. The solutions on DACA, of course, are that absent a family petition, and Victoria, I think those are not the changes that we send. We might have the individual slides on that. But if your DACA applicant qualifies for an H-1B, file for them right now, because DACAs can actually have H-1Bs. And we'll take the next slide. TPS. If you're in TPS, or if you have TPS employees, same as DACA, it will either be terminated or it will expire. I told you in the beginning, 4 of the TPS nations have just been renewed. It'll last until 2026. Do not expect those to be renewed. So something very important, if you have a TPS employee, and I know some of you do because I have spoken to them, if you have a TPS employee, they should apply for what's called advanced parole so that they can travel internationally. Because when they return with that advanced parole to the United States, they facilitate what's called a legal entry, something that typical TPS people do not have. But that will put on their record that they have entered legally, and some future immigration benefit may be easier for them to get. We'll take the next slide, please. U visas, T visas, I think we can skip that. I don't think any of our clients are in that category. Let's go to the next slide on that. Here's something that you will have to know. STEM OPT, and H4 EAD expectations. Prepare to lose them. This sounds very harsh that OPT might go away, optional practical training for academic students. There's been a lawsuit a couple of years ago, and OPT survived that. But I can tell you, OPT is nowhere to be found in the Immigration and Nationality Act. It's just made up by some administration in the 1990s. So it is there. It's a great benefit. The accusation on the street currently is, or the accusation by the incoming administration is, that universities in the United States use the OPT program to sell their academic programs to foreign national students. In other words, they are not advertising you can become a great engineer here at our university. No, they advertise if you study here for 4 years, you can have a student visa, and then you get 1 year of employment authorization in the United States. And the counter argument of the incoming administration is that this is basically a guest worker program that is taking jobs away from United States citizens. So be prepared to lose OPT and STEM OPT. Now, the solutions for that are, if you are in OPT right now, and if you have an opportunity that your employer is willing to help you, now's the time to file that visa application or that green card application. There's no point in waiting out your OPT. If you're in STEM OPT, please explore the national interest waiver. There is still a valid executive order from the Biden administration that STEM graduates qualify potentially for national interest waiver. It's a self-petition situation. You don't need an employer to do it. And I know there are a ton of NIW qualified Austrians in our universities here in the United States. How do we know that? We know that because we've spoken to many of them, and there must be more out there. If you are currently employed, ask your employer to start the PERM process, the green card process for you. There's no point in waiting. But in any case, if you are in OPT or in STEM OPT, you must enter this year's H-1B lottery to get out of this OPT thing, because it is not going to last forever. And let's go to the next slide, please. So I told you in the beginning, the H-1B modernization rule is going to go into effect tomorrow. So that's really some good news. And the H-1B lottery is coming up this March. We don't have the exact dates yet, but it's around the corner. Now's the time to get ready for that. Now, here are the good news about this rule. First, a specialty occupation is now defined what it is. So if a degree tells you what it is, then that's what it is. But also what the new rule says, that a similar degree might qualify you for an H-1B. Let me explain. If you, in the past, in order to be hired as an accountant in H-1B, you had to have a bachelor's degree in accounting. Now you could have a bachelor's degree in business administration with a concentration in accounting. So a similar or a familiar degree in the field will also get you that H-1B. Most importantly, there is deference to prior USCIS determinations. Meaning, if you have an H-1B already and it has been approved and you now have to renew it, under this new rule, the USCIS will give a deference to the previous petition, meaning if it got approved once, it's going to be approved again. There's going to be the H1 cap exemptions. Many of you know there is a cap exemption on the numerical limitations on the H1Bs where you don't count against those numbers. This cap exemption has been expanded. What used to be research organizations that are primarily engaged in research has now been expanded if there is a fundamental research activity within a business. That now means you don't have to be a research organization in order to be a research organization. If there is a department within your business or within your not-for-profit that does research, then that will put you within the cap exemption. All of our OPT listeners, all of our STEM OPT listeners know, of course, about the cap gap. That means, you know, when your visa, your H-1B visa, that typically becomes available on October 1st, and you have this gap between your OPT from May or June until October, you were granted this employment authorization. You could continue to work until the H-1B was available. This cap gap has now been extended for up to a year. So even if your H-1B job now becomes available after October, let's say in December or in January, your OPT work authorization will be extended until you get that H-1B. Now listen up. Many of you call the Trade Commission, Advantage Austria in New York, and you're a startup and you want to know how to do it, and it crashes right there because there's no visa available for startups. Really, only very few. Under the new H-1B visa rule, you can actually be an owner of a business and petition for yourself on an H-1B. That is absolutely huge. And the sooner someone can take advantage of that, the better, because this is not going to last. Many of you in the IT industry and on H-1B visas, you're in third-party placement, meaning you're hired by company A, but you're actually working on a project at company B. That company B will now be responsible for your H-1B visa. And two more things about that new rule. And you will see this coming with every immigration benefit down the road. Every benefit that we're going to get is going to come with some sort of enforcement. And in this case, in the H-1B rule is when you renew your case, you're going to have to prove that you maintained your status properly. And maintaining your status in H-1B is not just being here legally and entering legally. It means actually working in the job that was listed on the labor condition application. It means being paid the wage that was listed on the I-129 application. It means actually working in the MSA, the Metropolitan Statistical Area, in which the application was filed. So if your employer is in New York City and you're now working in Chicago, you're an H-1B visa violator unless you have actually amended your labor condition application. So be very, very mindful of that. And then, of course, there will be site visits. So if you employ H-1B staff, make sure your public access files are in order. Make sure your public access files for the H-1Bs are available to any potential visitors that you might get from the Department of Homeland Security. And with that, Victoria, let's go to the next slide. So that was the good news. So now here comes the bad news. We have a new administration coming in a couple of days. And there used to be an H-1B rule by the Trump administration 4 years ago. And many of you will remember, whatever Mr. Trump did all that time ago, he just fell into the room with the door. That's not how it works in immigration law. In immigration law, you have to write a rule first, and then the public has an opportunity to comment on the rule, and then the rule gets implemented. Well, Mr. Trump never did that. So there were a bunch of rules under the old Trump administration that all of them failed because there was never a public comment period. They never followed the rule of rulemaking. Well, we know they had a 4-year apprenticeship, so now they know. And they already have the rule in place. Now, the question is, are they going to replace the existing rule that's going to go into effect tomorrow with their rule? And here is what the old rule said. Of course, number one, buy American, hire American was the biggest thing. And they wanted to bring in the best and the brightest. I will tell you, the term the best and the brightest does not exist in the Immigration and Nationality Act. It's just made up. And we already have a visa category for the best and the brightest, and that's the O1 visa, the visa for persons with extraordinary abilities. And that really is for the best and the brightest, and not the H-1B. But what it will do, some of you who have done H-1Bs as a company, you know there are 4 different wage levels. And of course, you want to come in at the lowest wage level on the prevailing wage. But this is what that rule change will do. It'll get the wage levels up, and they want to price you out of the market. They will most definitely distort as to what is a specialty occupation. Today, if I have an engineering degree, an engineer is an engineer and an engineer. They will actually question that. And it is starting already. I will tell you, we have just received a request for evidence on a couple of days ago from an application for an H-1B application at a large university. They are bringing in a professor with a PhD, and the USCIS is now questioning whether that is a specialty occupation. Professor needs a PhD, and whether what he or she is going to teach is going to be the function of a specialty occupation. So you can see how crazy that already is. There will be fee increases. You know, the fees for the H-1Bs have increased a couple of years ago. The filing fees for H-1Bs are now higher than legal fees. If you want to bring someone in, you know, on an H-1B, I think the filing fees alone are in the area of $5,000 already. Not H-1Bs will be renewable because there will not be deference given to previous adjudications. And there will be site visits, there will be audits. And hopefully, you know, this restrictive rule is not going to be implemented, but we don't know. So here's what I want you to do if you can. There is something in the law that most people don't know about. If you amend your job description on an H-1B significantly, let's say you give your H-1B employee a promotion, you can actually file an amended petition and get an additional 3 years in H-1B. If that applies to an employee in your company, do it right now. If you want to keep that employee permanently, start the green card process right now. There is absolutely no reason to wait. There's no requirement that anyone has to have an H-1B for a certain period of time before the employer can petition for your green card. Now's the time to get this off the ground. And finally, please, and I mentioned it already, beware that your H staff is working in the MSA that's on the LCA, meaning that they work in the location that you put on the application and that the LCA was properly filed. And with that, we'll go to the next slide. PERM expectation. PERM is, of course, you know, the green card application, the labor certification process, the very classic way on how a worker, an employee immigrates to the United States, where a U.S. business, and all of our Austrian businesses located here are, of course, U.S. businesses. This is where a U.S. business has to demonstrate that it cannot find a willing, qualified, and available worker to perform the job duties that are required at that business in the location where the business is located. The old classic way to immigrate to the U.S. So here's what to expect on PERMs. Buy American, hire American. We're going to have to really show that there is no American available in the area where the job is being offered. So the recruitment is going to be more difficult. Recruiting in the open market is going to be scrutinized more by the Department of Labor than it has to. We expect an increase in the prevailing wage determinations, that, you know, wages that hovered at X are now going to go up. there will be an increase of processing times. The best way to annoy and to discourage an applicant is for the government just to sit on the application, and they're very, very good at that. So expect an increase in processing time. There will be more anti-discrimination lawsuits because you're going to have to prove that you're not discriminating against American workers, because the attitude in this country is whatever you can do, an American can do. Those of you who manage their perm applications in-house, I mean, if you have an immigration lawyer already, he or she knows about what the ONET is, but if you manage your immigration in-house, beware of the ONET upgrades and downgrades. I can only recommend to you, when you start a perm process, when you start one of those green card processes and you have found that job description on the ONET, print it out with the date, so that later on that there is no argument when you're being audited as to why the wage is what it is and as to why the job description is what it is. Because if you lock it in with a printout, they cannot get to you on that. So your solutions on perm obviously are get the perm process started. Do not wait. There is absolutely no reason to wait on that. And again, be aware of any ONET updates. And with that, Victoria, let's check the next slide. There's some more visa categories that I believe apply to our Austrian companies. NIWs. Those are the national interest waivers. You know, prerequisite is that you have the minimum of a master's degree, or that you're at the level of a master's degree, and that whatever you do is in the national interest. We have done a lot of those applications for Austrians. We know they are out there. Here is what you need to watch out for. There is currently an executive order from the Biden administration that if you're a STEM graduate, that you likely qualify for an NIW. That executive order will be rescinded. And that's not a speculation. Well, it is a speculation, but I promise you, it will be rescinded. Any executive order that Mr. Biden signed will be rescinded at 12:30 on the 20th. So if you have not filed your NIW yet, now is the time. You got to do it. Or if you have an employer, ask him or her, ask HR whether they can move ahead with your green card application. I know many Austrian companies have L1As and L1Bs. There could be a prevailing wage requirement coming, especially for L1Bs. I'm just throwing that out there. Beware that this might be the case on a visa renewal. We're not certain about that yet. But if I can advise you on anything on that, if you have an L1A executive within your business, there's absolutely no reason that you do not convert that now to a green card. As you know, on L1As, there's no labor certificate required. Now's the time to file that I-140 petition. If your staff member is on an L1B, you can't do that. You have to go through the labor certification process. There is absolutely no reason, if you want to keep that person, there's no reason not to go ahead with the labor certification application right now. Some of you might also have staff among your crew that are here on pending asylum, and you might not even know that. But again, you know, it'll be helpful to identify those folks so that we can advise them properly on what to do so that they can continue to retain their status and that it doesn't go away. There has been talk that the particular social group will be eliminated within the asylum context. Personally, I don't believe that because it'll require Congress to do that. And I think we can all agree we have seen the great work the American Congress does over the past decades or two. They do nothing. So I'm not worried about that at all. And we'll take the next slide. So this is something that's going to happen. So please, this should be a takeaway, this slide. FDNS is the Fraud Detection and National Security Department of the USCIS. There will be site visits and audits. And when I say there's a site visit or an audit, do not take that lightly. It goes down to, ICE and also HSI from ICE that will do I-9 employment eligibility compliance. Here are the things you need to do in that. Number one, if you have a compliance program, an I-9 compliance program, it needs to be reviewed and updated. If you do not have an I-9 compliance program, it is now the time to get one and write it up. There is nothing like good faith when it comes to a site visit and having a compliance program on site. There will be audits, and just because you are the executive of a business, do not think that you're insulated from the results of an audit. But more importantly, what I want to implore on you today, your staff needs to be trained on what to do if there is an unexpected audit, or if ICE or FDNS or HSI, when any federal officer walks into your building, because they show up, they're very nice, they're very friendly, and they will speak to your receptionist, and your receptionist is going to give the bank away. So we need to train the front office staff on how to conduct themselves when the government shows up at your door, what to do. You have rights. And this should not fail at your front office, where we have, and I'm not making this up, we have seen this over and again, where there is a site visit, there is H-1B staff working on site, and the FDNS walks in and they talk to the receptionist and they ask, what is Mr. Miller, he's working here, what is his job and what does he do? I promise you, you do not want your receptionist to answer that question, because that officer already knows what the job description for Mr. Müller is, and we got to make sure that either HR or an executive or someone designated speaks with that officer. And again, we've seen it over and again where things go bad because our front office staff or someone else means well, they want to be helpful, but yet it causes a real problem. The next thing that's going to come, and many of you who are doing business in the US already have E-Verify. For those of you who don't know what it is, E-Verify is a collaboration between the Social Security Administration and the Department of Homeland Security, whereas E-Verify can tell you within 30 seconds whether a person is eligible to work legally in the United States. E-Verify, if you're already bidding on government projects and what have you, you already have to have E-Verify for that. In some states, it's mandatory already. This will become mandatory. So if you don't have E-Verify yet, now's the time to get it. Don't wait for the government. If you need any advice on how to do that and what the pros and cons are of E-Verify, we'll be happy to teach you. We'll be happy to consult with you on that. There will be some regulatory action to limit classes of aliens eligible for employment authorizations. We already spoke about STEM OPT, we spoke about OPT, we spoke about H-4s. This will surely happen. And that's another thing that I want you to watch out for. And that's the Immigrants and Employee Rights section of the Attorney General of the Department of Justice. That's a big thing. We do not discriminate in the United States. Of course, we don't discriminate in Austria, but you might be discriminating without knowing that you're discriminating. So having an anti-discrimination policy in your business as to how it relates to hiring and firing, and how it relates to petitioning for foreign nationals for visa benefits and green cards is a very, very important thing. This has come to the forefront on or about 2021. We call it the Facebook case. Facebook at that time was accused by the Department of Labor and by the Department of Justice to hold permanent jobs open for people who they already employed in H-1B status, and that they did not offer those open jobs to American citizens. The Department of Labor was never able to prove it, and the Department of Justice was never able to prove it either. Why? Because Facebook settled for several $1 million to make it go away. But that is not the modus operandi that you can count on. So if you don't have a written non-discrimination policy, please contact us so we can point you in the right direction on how to remediate that and how to rectify that circumstance. And we'll go to the next slide, please. So here's the summary of what to expect. All Biden executive orders are going to be gone. So whatever you benefited from, it's going to be gone. There will be increased processing times stateside and abroad. This is important. You got to remember that, because you've got to plan ahead. Just imagine you were sending Mr. Miller to wherever. We're going to send him to Bratislava to have his H-1B extended, and he's going to be gone for 3 months. We can't afford that because we need him stateside. So especially visa renewals, you got to plan ahead. There will be complex RFEs, notices of intent to deny, and denials from the USCIS. I just told you a minute ago the ridiculous RFE that we got on this university professor. We will get RFEs on the most onerous things, on the most simplest things. The downside is, it just holds you up. The good thing is, we can resolve that. It's not an issue, but it's time consuming, it's expensive, and it's a business interruption. There's definitely going to be increased consular scrutiny and extended administrative processing. Many of you, unfortunately, can sing a bad song about that. Increased consular scrutiny means that if let's say an L1 has been approved by the USCIS, and now your candidate goes for visa issuance at the post overseas, they're going to look at that L1 all over again. Are they entitled to that? No. Unless there's obvious fraud, they shouldn't do that, but they will. Extended administrative processing. This is probably the most annoying part, because administrative processing happens in every visa issuance case. Unfortunately, this is something that we cannot avoid. It is something that we cannot file litigation on, and it's something that we can't get any information on. It's this big secretive thing where your personal data is being sent back stateside, and then it is run through all of our security agencies to see whether they can find a hit. If they can't find a hit, they start misspelling your name and permutate your name and put the last name first, the first name last, and what have you, until they find something or try to find something. There could once again be a limitation on visa issuance for certain countries. Those of you who were here under the first Trump administration remember the travel ban that we had. So if you have employees from certain countries, there's a possibility that there's a travel plan. So if you don't have to travel, please don't. Buy American, high American, yes, we'll be back. We spoke about site visits and audits, and there will be no more deference to previous petitions. So now let's wrap it up with the next 2 slides. So if you are an employee and you're listening today and you're on a visa, then you should review your immigration sponsorship with your employer as soon as possible and strategize on the next step. If you are within a window to renew, do not wait. Do it right now. Any visa and any immigration benefit can be renewed or applied for renewal 180 days prior to expiration. Do not wait until it's 2 months out. If you're within the 6-month window, get it started today. And if you qualify for self-petitioning, like extraordinary ability or national interest waiver, get off that chair, do it right now. Get going on that. And with that, we'll go to the last slide. And this is for all of our business owners, for all our managers and executives. So you definitely need to assess your sponsored employee population and figure out, what status they're in and how this new administration, if at all, is going to impact you by either travel bans or by visa renewals or what have you. Then we got to figure out, do you have anyone in H4? Do you have anyone in TPS? Do you have anyone in DACA? All these categories that we spoke about that might be going away. And then let's see, what is it that we can do right now to save those employees? How can we get them into a different visa or immigration category? Most importantly, conduct a compliance audit. If you don't know how to do that, we have been doing audits for world-renowned businesses for many, many years. We know what to look for. We know how to guide you on that. We'll be happy to help you to get your I-9 household in order. As a matter of fact, I'll go this far. I promise you, if you email me 10 of your I-9s, I will find a mistake. Just pull them randomly. And then evaluate your hiring practices. Make sure that your onboarding, your recruitment is consistent, with what you do for everybody. There can't be a difference on how we do things for our Austrian employees and how we do things for our US employees. Treat like employees like. A very, very important thing. If you don't have a policy on that, like we discussed, again, feel free to reach out to us and we'll be happy to support you with that. And with that, I'll turn it back over to Victoria, and let's see if we have some questions. And I thank you for listening to me for such a long period of time.
Thank you, Christian, for that very in-depth overview. We really appreciate it. Please feel free to ask your questions in the chat, or you can also turn on your camera and microphone and ask your questions either in English or in German, whatever you feel more comfortable with. However, before we go to the questions, I would like to give you a little overview of what Advantage Austria New York is planning for the next months. Since all of you are apparently interested in the US, some of our events might be interesting for you. Some of you already have businesses in the US, but some don't, and they are thinking about it. We as Advantage Austria New York started a couple of years ago, actually, with our signature event called Boot Camp. And at the boot camp, in a 4-day event with workshops, very specific, covering very specific topics like do's and don'ts in the US, legal questions, tax aspects, how to recruit, how to do marketing, and so on and so forth. We do have 2 upcoming boot camps. As I said, very, very interesting and valuable for people who want to open up shop here in the US. And then also upcoming, we do have a webinar about chances for doing business in the US on January 28th. We do have an upcoming what we call Zukunftsreise, look into the future about AI in Boston, including a visit at an MIT, Massachusetts Institute of Technology conference. Also following in April, we do have in Atlanta, Georgia, a specific event covering aviation. And then in June, for everyone who is in the life science and bio business, the Bio International Convention, also in Boston. You have the QR code on the right side, but I will also go ahead and share the links to all the events in a minute. And stop sharing now and go back and see if we do have a question. Christian, Paul is asking, do you expect changes to the E2 investment visa?
I do not expect, Paul, any changes to the E2 investment visa, because the E2 is based on a bilateral treaty between Austria and the United States. So if there were a change here in the US to the E2, that same change would have to be made for US citizens in Austria. However, having said that, what I can envision on the change that I can envision on the E2 is for E2 employees, that there could be a wage requirement, that the Buy American, Hire American is definitely gonna be an issue. As you know, there are 2 categories of E2 employees. One is the essential employee and one is the managerial capacity employee. I think the managerial capacity is the easier category to get through, but the essential employee could become more difficult. because how long can essentially last? That's also in our Foreign Affairs Manual, so that's been questioned already. So there's a possibility that there's an impact on E2 employees.
Amazing, thank you. And yeah, we know especially the E2 category is very important for many of you. For now, I don't see any more questions. I also put in the chat the upcoming events and also our email address. So if afterwards a question comes up, then feel free to also add it there. While I was talking, there was one question coming in, this time in German. Herr Freller Jr. absolviert derzeit ein Praktikum in New York, OPT. Sein Problem ist die Anmietung einer Wohnung. Yeah, please feel free to reach out to us afterwards, since this is not specifically an immigration question. I see Frau Ms. Tanja Zemasch, feel free to turn on your camera and ask your question.
I cannot hear Tanya. I don't know whether you
No,
do.
me neither. It should be possible for her to turn it on. Okay, there was another question in the meantime coming in. We want to bring two of our business managers, Austrian citizens, to the US because they're a crucial link between our Austrian operations and US operations, and keep them there for a longer period of time. Also potentially assisting with brownfield projects. What is the best way to do that? H1B? And what are the costs and time implications for that process? And how will the policies of the new administration impact that?
Well, I am not sure whether the H-1B is the right category on that, because as you know, the H-1B is subject to annual numerical limitations. So we'd have to enter that visa lottery, and then, if we are not chosen, then, we can't bring those gentlemen here under the H-1B visa category. I'd be interested in learning more about your Austrian and US business so that we can determine whether you are or whether your executives are E2 qualifiable or maybe L1 qualifiable. It seems to me that might be the better category, but it would depend on the size of your business and the business activities that you're planning on and the business purpose. So I'm sorry that I can only give you a generic answer on that because I don't have enough detail. But you're very welcome to to reach out to Victoria directly, and she'll forward your information, and then we can talk about it in more detail. But I don't think that the H-1B is the right way to go.
Okay, there are now
Hello?
a couple of questions coming in. Yeah, no, we can hear you now.
Okay, yeah, I managed to turn on my mic. I'm very sorry. It was disabled before. Now I managed to turn it back on. Tanya here. So we've had a group of field service engineers, Austrian citizens and a Croatian citizen traveling on a B1 visa with the annotation of industrial worker. What should those guys expect during the Trump administration? Are they going to be subject to more scrutiny from immigration officers?
I don't think, as long as we're not talking about a visa renewal, Tanya, if you have field engineers that come here to supervise and install or train only, and as long as this activity is enumerated in the contracts between the Austrian and the US businesses, that this is part of the service, I don't see an issue with that.
Okay.
Because in this case, it's really not the Buy American, High American, because you already brought the Austrian product here, and now you're servicing an Austrian product.
Yeah, I mean, especially they do a lot of manual work, especially for first in fab equipment, because there's not the knowledge or the expertise in the American regional teams is not existing yet, but it's being built up. So we'll have to for sure tweak our contract work. I'm guessing, looking at what you've elaborated on.
I agree with you, and if I may add, specificity is everything on that.
Yeah.
To really explain the complexities of what your engineers do in order to continue to make the wheels turn on the stateside projects. That's going to be key to continue doing that with the B1. And then again, I'll be happy to review your, whatever your plan is, and maybe, there is another visa possibility that does away with the scrutiny on the B1 that you continue to have.
Yeah, we've been advised by our visa agency to switch to the L1B, but looking at what you've told us, this isn't going to be much easier exactly. So I guess
once the L1B is issued, I think it'll be a good thing. But I would have to learn more about what the specialty is to see whether it is truly L1B qualifiable. Your advisor is probably right, but it's a hurdle. It's a hurdle to clear. There's no question about it.
Yeah. Okay. I'll talk to my managers and to the guys, and then I will probably reach out to you to make sure we do the right thing going forward and not get people into trouble.
I look forward to it.
Okay, thanks much.
Thank you.
Thank you for that question. And there were a lot of questions coming in. I would say let's answer one more question, and the rest we can answer via email afterwards. There's one question regarding it's in German again. Funktioniert die Visabeantragung mit slowakischen Mitarbeitern und dann slowenischen Mitarbeitern besser als mit österreichischen Staatsbürgern? Gelten die gleichen Regeln für EU-Bürger in allen EU-Staaten?
Ja, die Regeln sind alle gleich. Es kommt natürlich immer auf das Konsulat drauf an, wo der Antrag eingereicht ist, wie er dort behandelt wird. Aber das Gesetz ist für Österreicher, Slowenen und Slowaken dasselbe, und das amerikanische Gesetz ist nur eines. Also es ist wirklich nur die Einstellung, die man in einem gewissen Konsulat oder auf einer Botschaft hat, aber ich sehe da überhaupt keine Unterschiede.
Perfect. All right. As mentioned, we will answer the rest of your questions via email. You will also get the recording and the slides in the next few days. And anytime, if you have any questions, I put our email address in the chat. Do feel free to reach out with those questions. Christian, again, thank you so much for the overview, for giving us an idea of what might happen in the next probably months, but also in the next 4 years. It's still uncertain, but now I guess we're better prepared. Thank you again. Thank you for joining to everyone, and hope to talk in the next few days, and with any questions, as mentioned, feel free to reach out to us. Have a wonderful day, and goodbye.
Goodbye.